over as we're thinking. All right, so for this morning's session, we thought that it would be nice to have some people who are experts talk to us about how to do psychology research. And the idea behind this was there are a lot of us, especially in legal academia, who are interested in psychology and think it has great value and think that it can be very helpful to lawyers, but many of us, and especially including myself, have little or no psychology training, and we might be a risk to the world if we just try to spout out whatever we think and we don't really know what we're talking about. So to try to help us do a better job, those of us who don't already know what we're doing, we brought in two experts to talk to us about how to do psychology research. They are Jennifer Robinold and Rebecca Hollander-Blumoff. Jennifer's at University of Illinois, Rebecca's at WashU. They're both JDs, they both teach at law schools, but they also both have PhDs in psychology, and so they know what they're talking about. So with no further ado, they're going to try to share with us how to not butcher the field as we try to apply psychology to law. Lawyer. Ladies?
So I'll start by telling you a little bit about how we understand our task this morning. But before I do that, since I have the microphone and it's first thing in the morning, I really think we should all thank Jean for putting together this conference. She's done a wonderful job, both substantively and logistically, in putting this all together and keeping it running. And so I'm very grateful, and I know all of you are as well. So Jean gave us this task of talking to you about how to use psychology research in lawyering, and as she just described, thinking about how to do psychology research, and we know that you all have a pretty wide range of backgrounds. We know there are a lot of people here who do psychological studies, but also even more of you that are more likely to use the psychological studies in your work. And so we have decided to pitch this primarily to the consumers of the psychology and to talk with you a little bit about how to find the psychology, the importance of finding the original psychology, and some suggestions about some things to think about as you're diving into the psychology. So that's our task, and I want to start briefly with maybe something of a cautionary tale. And so Hans Zeisel did a lot of jury research, and he tells a story of seeing all sorts of publications with advice to lawyers, people coming up to him and saying, oh, I heard about this finding that you have, and the finding was that 80% of jury trials are decided after the opening statement. And you could see this written in all sorts of places. People would discuss it. It was sort of common knowledge that this was the case. And when it was attributed somewhere, it was attributed to this book, Calvin and Zeisel's book, The American Jury, a classic book on jury decision-making. The problem is that they did not find this. And Zeisel went back to the book. He looked for the phrase opening statement. And in fact, nowhere in the book does it say opening statement anywhere. Okay? And so this psychological finding had been reported and perpetuated and eventually, all cited back to this book, but the original source did not actually support that finding. And so perhaps the threshold caution is sometimes what we're talking about as the psychology is not really borne out by the original research. That's not primarily what we want to focus on, but I think it's a good reason to actually go back to the original sources. Instead, what we want to focus on is how do you get to the original sources, and then when you get there, how can you use them in a way that's going to maximize your ability to use them to offer insights for lawyers and law students about how to go about lawyering. Because I think we both think that there is a gold mine there that has been, in some cases, tapped in a nuanced way, in some cases tapped sort of only superficially, and there's a whole lot more that you can get by going back to the original research. So we're going to start out by talking a little bit about how to find the research. We're going to tag team a little here.
I just want to echo Jen's thanks to Jean, and this has just been terrific. So I'm going to pick right up. I'm talking a little bit right now about where you can find psychological research. How do you go about getting what you need in terms of what's out there in the psychology world when you come from a different discipline? So I'm going to talk about all of these things, but I'll give you a little bit of a broad overview, and then I'll get a little bit more in depth. So law reviews are a thing that most people in this room are pretty comfortable with, right? You probably have them in a faculty lounge somewhere, or you know exactly how to find them on Westlaw or Lexis. And a lot of times there's some really interesting stuff in those journals about law and psychology. There are a lot of great people working in law and psychology right now, and so you might find some great beginnings. But I really want to caution you, that is only the start, right? Because we find this effect, right? Even in the law review, sometimes we will see a footnote that attributes something that when you go back and you look at the primary research, it's just not there in the way that it's stated in the law review. So it's a fine place to start, but it's not a fine place to end if you're looking for psych research. And I know, those of us who are really into this area, we do sometimes see things like, oh, and prospect theory and loss aversion, and then you see cite to another law review article by, say, Karobkin. And that's great, Karobkin's done great work, but he didn't invent prospect theory, and he didn't do the findings on loss aversion, so you want to see the additional research. So I also kind of have a kind of a two-directional presentation in this portion here, because some of you have library access to lots and lots of online databases, and that's wonderful. If you're part of a big institution that carries those subscriptions, that's great. Some of you don't have that access, and so if you don't, I have some commentary here. This presentation piece is actually kind of good for everybody, right? People who have that access to to the databases through the library, and people who might need to pay per article, you can kind of glean stuff from both of these. So both of you can glean things from this. So I'm going to talk about SSRN, also PsycInfo, JSTOR, author pages, and Google, but I'm going to go through that in a little more detail. So what I did here was I built a Potemkin village for you of an internet search. We don't have a real internet search because, when you do that, you're kind of tempting fate. So what I have here is I started with Westlaw, and of course you can't actually read this because it's so tiny, but I'm going to tell you, it's Westlaw, it's our lawyer's home turf, right? And what I have here is a search for psychology within two negotiation, right? We're also, we love Boolean searches, we know exactly how to do those. And you can see you get a whole bunch of articles in law reviews on law, on the psychology of negotiation right away. And that's going to be kind of the key to the kingdom to hopefully get you to some other research. But, as I said, it's not the place to end. Another place that many legal academics are pretty familiar with, but if you're not a legal academic, you might not know about, is SSRN, which is a free public website open to anyone. You can go on SSRN and you can look for all kinds of papers. These are papers that are both unpublished and published papers. Many of them are on there. It's not a complete set of them, but there's a lot there, and again, it can give you a kind of an insight into what might be out there, and you can find a lot of sites. This here is actually something called the Law and Psychology e-Journal on SSRN, and you can go to the Law and Psychology e-Journal on SSRN. You can just Google Law and Psychology e-Journal SSRN, and it will take you to this page. And this is some of the most current work that's been kind of filtered in this journal. The journals in SSRN are just kind of groupings of relevant articles. And you can see right here, very top article is by Tom Tyler and Justin Seaver on how do the courts create popular legitimacy, something you all know a little bit about now. Right? Okay, so getting a little bit further afield, we can look at APA PsycNet if you are somebody who doesn't have access to a private library. If you do have access to a private library, you might want to look at psych articles, PsycInfo, and both of those are places where you're either going to be able to get abstracts of psych articles or the full PDF text. But as I said, for those of you who don't have the library access, you can see here on this screen, I did a search here, I did a search for death penalty. And this is public and free, right? This is public and free. I did a search for death penalty, I come up with a bunch of articles. And then you can see on this column here, down where the little PDF icons are, that they say purchase PDF. So even if you don't have access to this through a library, you can buy it if it's something that you think is super interesting. They're not crazy expensive, like $12, something like that. Okay, you can, I think that's the, yeah. So this is just further afield, and you can search by keyword in these databases. It's very similar to what we do in Westlaw, searching by keyword. Okay, there are other sources out there too. JSTOR, that stands for Journal Storage. That's a big social science database, and that again is you need to pay to access it, but it's a great resource also. Another thing that you can think about doing is there are some dedicated law and psychology journals, and you can go to their websites and you can look at what's going on. You know, you can go to the Law and Social Inquiry website or the Law and Human Behavior website. There are other journals. These are only an example. If anybody wants to talk more about what those journals look like, I'm happy to chat later. But you can go to the actual websites of the journals and look at the table of contents and kind of browse and see what looks interesting, and you can pay to buy those articles if you don't already have access through your library. You can also find, once you find some author that you're really excited about, somebody who's doing research that you think is fascinating, you can go to their page, their author page. Many of the psychologists, I'd say most of them who are doing a lot of research right now, they have an author, they have a page on their website that will show you all their recent work that's in press, and that's a great way to sort of see what's going on in a particular field once you find somebody that you think is doing work that's relevant to you. Okay, so the last thing I want to say before I pass it back to Jen for defining variables is that Google and Google Scholar also can be very helpful. I went on Google Scholar last night. I typed in Tom Tyler. I became one of Tom's books in Google Books. So, you know, there's a lot on the web if you kind of start with either an author or a topic, and you can get to some very useful places that are both free or accessible for not a crazy amount of money.
Okay, so the next question is, once you've found it, what are you going to do with it? And it's tempting for all of us to sort of look at the introduction and then to look at the discussion at the end, right? And skipping all the math in the middle, right? This is your numeracy level, but it's tempting to sort of skip over that because in the beginning and the end you're getting sort of conclusory statements about what did they find, right? But we want to encourage people to actually really dig into the methods section and the findings section so that you can really think carefully about what exactly have they found and what are the parameters of those findings. So what we want to talk about first is thinking about what variables the researchers have used and how did they define those variables. The term we will use in the field is how did they operationalize those variables? How did they measure those variables, or how did they create or define the thing that they are measuring, right? So I'm going to make that a little concrete by giving you some examples. So you might see something in the literature about the relative merits of engaging in aggressive negotiation, right? And you might find studies that say if you're aggressive in negotiation, you're going to do better on some objective outcome measure. You might find articles in the literature that say aggressive negotiators don't do as well, right, for all sorts of reasons, right? And it's not that the literature is necessarily just completely not useful in finding contradictory things, but if you look closer, you may see that the way they've defined what it means to be aggressive in negotiation is different, and different ways of being aggressive have different outcomes, right? So you might have a paper that is thinking about aggressive negotiation as being something about bargaining style or interpersonal relations within the negotiation, and people are acting in an aggressive interpersonal way. You will find studies that talk about being an aggressive negotiator, thinking about that in terms of how high are your aspirations. Are you really trying to get something significant and with a high goal going into negotiation? That may be a completely different kind of thing than the first kind of aggressive negotiation. It might have to do with being tenacious in your use of available procedures, right? Maybe coupled with or completely separate from either of the other two. It might be something about how determined the negotiator is in terms of brainstorming or in terms of how aggressive they'll be in terms of investigating facts, right? And you can, I think, pretty easily see that depending on what kind of aggressive negotiation we're talking about, we might expect different kinds of results. So you want to be careful that some generalized statement at the beginning or the end of the paper about aggressive negotiation is sort of more nuanced. Each study is going to be fairly narrow, and the results are tied to the way that they have instantiated the particular concept. Okay? I'll give you another example. You might be looking at studies where one of the measures is about settlement rates. How frequently do cases settle out of court? Right? And people that work in this field have all sorts of issues with cases that aren't cleanly falling into settled or not settled. So what do we do with default judgments? What do we do with cases that are dropped without payment? Is that a settlement? Is that not a settlement? What do we do with claims that are dismissed for lack of prosecution? And depending on the purposes of the research, the researcher may count some of these things as settlements, or they may not, right? So you need to sort of know what their purposes were, how they measured this concept, and how does that mesh with what your purposes are in using the research. A third example might be someone who is thinking about what do we know about witness reports and what kinds of things affect the quality of witness reports and what witnesses are able to say. And you've got studies looking at witness reports, but some of them are asking the witness to say something about how much time did they have to view the activity that was the subject of their witnessing. Other studies may be asking them to estimate something about distance. Other studies may be asking them something about some subjective assessment of how much attention they paid to the event. Others may be asking, how good was your view? Those are all different questions. And again, they're affected differently. So for example, there are studies about the effect of sort of positive interviewer feedback, saying, oh good, or that's right, or something like that. It actually turns out that it affects these questions differently, right? So you want to be careful to really look at, in the particular study you're looking at, how did they define the variables and how did they measure them, and that will give you some insight into how applicable or not applicable it is to what you're doing, and how it might be most useful to what you are doing. All right?
So once you think about these variables and how you're going to measure them, then I'm going to be talking a little bit about what you do once you get the results. Once you've read these results and you're trying to figure out how to apply them in whatever you're doing. So I'm going to tell you the story of a study called, it's called I'm Innocent, and there's much more in the title, but that's the kind of key piece. And what this study by Casson and Fong does is it has individuals who are trained in the READ technique, which is a technique in law enforcement for trying to figure out whether witnesses or suspects are telling the truth or lying. And so in this study, what the conclusion is that individuals who are trained by the researchers in the study, trained in the READ technique, are no better. They're actually worse at detecting truth and lies in interrogation than untrained people. And not only are they worse at figuring out whether someone is telling the truth or lying, but they are more confident because of their training, right? And this is a great finding, and it's so interesting, and it's really, wow, we're training people, we're telling them they know exactly what they're doing, and then it turns out that they're worse and they're more confident, and you can see the obvious implications for the law, and you've got police on the stand. How confident are you that I'm very confident that the suspect was lying to me? Okay, so that's great, and it sounds too good to be true in some ways, and it can be if you look a little bit more closely at the finding. So how do you look more closely at the finding? In what way do you think that there might be a challenge here? Well, you have to look at whether the variables that you're manipulating in the study reflect something about the real-world conditions that you're interested in, right? And that's the external validity piece, right? So you might really be measuring what you think you're measuring in the study, but when you go outside the study, it doesn't carry over. It doesn't apply to the general population. So looking a little bit more closely at the I'm Innocent study, which I love, so I'm not trying to pick on it, but looking a little bit more closely, what you have in that study is you have students who've been told to go and commit one of 4 crimes. They go and they commit a crime. They shoplift, or they do a breaking and entering, or they do a couple other things. And then they're grabbed by the police who interrogate them, right? And they've been told by the researcher, make sure you say you didn't do it, right? Say you didn't do it and be convincing. And then you've got another group of people who actually didn't do anything, and they're grabbed too, and that's our control group, right? And so then those situations are videotaped, And then students, a different group of students, watch the videotape and try to figure out whether the suspect is lying or telling the truth. So when you look a little bit more closely at this, you might start to worry, right? Because you've now got suspects/culprits who were told to commit a crime, right? And then they're lying about having committed the crime, but they've been told to lie about committing the crime. So they're actually following instructions, right? They're doing something that they're supposed to be doing. That's how they're going to get paid for being in the study, right? And then on the other end of the experiment, you have students who've been trained in a read technique. And how have they been trained? They've watched 15-minute segments of the read technique on video, 2 15-minute segments. There are 4. Part of the whole series, but they haven't received any other training, right? They haven't actually had a real live teacher who's talked them through this. They've just watched basically a half-hour of YouTube videos, which I show some of to my class, and they're kind of rude, but that's what they did. And then they watched these videos and they felt more confident about their ratings, and they were worse than the group that hadn't watched it. So when we start to think about the external validity, we've got student criminals lying, sort of, and we've got student read technique users who aren't the same passively as our police population. So we've got some real external validity problems, and I have sample population up here, right, because that is a related issue. The sample is part of what is problematic here about the external validity, right? We might think that these college students involved here are really different than the population of both criminals or criminal suspects, and the actual police interrogators. So you really have to look closely at these factors. And I want to talk about another study. Similarly, I'm not trying to pick on Cassie, great researcher, but this is a great study too. It's so fun. It's super short. I recommend it to read just for fun. This study has a finding, and the finding, if you kind of took it at its biggest level, and the most exciting for lawyers, right, would be we can get individuals to make false confessions. And we can even get them to manufacture details about what they were supposed to have done when we subject them to stressful conditions and we provide a false witness. And this is, I mean, the findings here are phenomenal. Right? We had 69% of the subjects who signed a false confession, 28% of them really seemed to believe that they had done something wrong, and 9% even made up details about the crime that they had supposedly committed. Right? And in fact, in the condition where you had a witness and you had stressful conditions, 100% of them signed a false confession. 65% came to believe that they did the thing that they were accused of, and 35% actually made up details about how this had come about. Then you actually going to look at the setting a little bit more closely, right? And you find these are students, and they're being asked to do an experiment, and then they're told if they press the Alt key, the experiment will be ruined. And then a witness, in some cases, says, you press the Alt key, you run the experiment. In other cases, the experimenter just says, the system crashed, you must have pressed the Alt key. In other cases, there's, it's crossed with different cells, different conditions, right? But they have this great finding. But then when you think about the population, you think about students typing on a keyboard and, individuals acting in criminal ways out in the real world, maybe they start to look a little bit different, right? So you have to think about the external validity of these confessions. There's very low stakes, right? What do they have to do? They have to say, oh, I'm sorry, I ran the experiment, right? Versus I have to go to jail, right? So you really have to think about how the variables that you're manipulating, even if they really do measure some kind of internalization of having done done something wrong, or I've made up details about how I did something wrong, do they really carry over to the real world setting? Is there external validity here? Okay. Next, I have one more. I think I have one more before I turn back. Okay, so I wanted to speak a little bit more about samples. So there might be some particular issues that you want to be alert to when you think about samples in the legal setting. There are always going to be trade-offs between lab studies and field studies, but when we think about a lab study, some of the advantages of it are we're going to get very clean data. We're going to get very clean data, but it's rare that we have a lab study that actually involves lawyers, right? Or that involves defendants or plaintiffs, real defendants and real plaintiffs. That's that's going to be pretty unusual, right? And so the psychology in the legal field is a little different than psychology in some other areas, like cognition, right? Because when you think about cognition and information processing, well, everyone's a person and everyone's going to be processing information, right? That if you're looking for a particular finding that doesn't necessarily have some field-specific payoff, you might not be that worried. But here, typically, we care about the legal system and legal actors, and we're particularly interested in what lawyers do, or what defendants or what plaintiffs do. And so, given that most lab studies don't involve that population at all, we're going to be concerned sometimes. So you're going to have clean results from the lab, but we're going to be worried about the real-world applicability. If we have a field study, great. We're going to be out of the field. We're going to be actually talking to real lawyers, real cases, real people. But we're going to have a lot of problems with confounding variables, and we're going to have broader applicability, but we might be more worried about the results. I want to just say briefly something about the size of the sample before I turn back over to Jen. And that is, probably everyone in the room is totally aware that if you looked at a study and it said, say, we surveyed 4 attorneys and this is what we found, or we looked at 2 criminal defendants, and right, that would be ridiculous. So we're all pretty aware of the perils of a small n. But I want to mention here the perils of a large n. That might be something that some of you aren't as familiar with. It's something that has been referred to as the crud effect. The idea is if you have too big a sample, right, you can find almost anything to be statistically significant. You might find a very small effect, but you can find statistical significance for it if you have a humongous sample, right? And so you just want to be alert to that problem also. Okay, I'm going to turn it back to Jeff.
Okay, so once you've thought about what the variables are, and you've thought about how they apply and how they compare to the real world conditions, the overarching message is that you want to be really careful about overgeneralizing from one or a very small number of studies to some broader proposition about law or lawyering. Individual psychological studies tend to be fairly narrow, and that's often on purpose, but we tend to not always appreciate how really narrow they are. Right? They are a specific instantiation of a particular way of thinking about a variable, a particular population, a particular sample, and we want to be careful in drawing conclusions really broadly from those narrow examples. Psychology is often about exploring what we would call boundary conditions, right? And the language I'd like to use is we want to know something about whether there's an effect, but not just whether, but whether and under what conditions do we see an effect, right? And the under what conditions part is what we would call boundary conditions, right? When do you see a particular effect? And then under what kinds of circumstances do you not see an effect? Or do you see the opposite effect, right? And so I want to give you a couple of examples of when we think about this in a more complicated way, the kinds of things we might see. Because it's really easy to sort of think about, is there an effect or is there not, right? So one example is something that came up a couple of times yesterday. Lots of research on perspective taking, lots of research on the effects of perspective taking that might be conducive to cooperation and agreement in legal kinds of settings. We saw yesterday there's less stereotyping, right? More objective assessments of fairness, more cooperation, and so on. There's also a whole body of research that shows that perspective taking can increase antisocial behavior, selfishness, retaliation, and negative views of outgroup members, right? So again, this is a situation where you might say, well, okay, what are we supposed to do with that, right? The studies are messed up, or it's just a mess and we can't take anything away from it. But what we want to do is think about, are there conditions under which we will see one or the other of these kinds of effects? And so there might be lots of different things, but I'll just suggest that one of them is whether we are in a competitive situation or a more cooperative situation. So this is a study that was looking at perspective taking, and the behavior here was whether someone would misrepresent a key piece of information to their negotiation counterpart. And on the left-hand side, you can see the people who were not perspective taking in any particular way, and whether they were in a cooperative situation or a competitive situation didn't matter very much. On the right, you see the people who were told to take the perspective of the person, and they were given specific instructions about how they were supposed to go about doing that. And you can see that perspective taking, when it was a competitive situation, increased the amount of misrepresentation that there was, while in the cooperative situation, perspective taking decreased the amount of misrepresentation. So we would call that in psychology an interaction, right? There's some variable, in this case, whether it's cooperation or a competitive situation, that changes the effect, that moderates the effect of another variable, that being the effect of perspective taking on the amount of misrepresentation, right? And so if you're looking in detail at the particular research study, and in this case, the body of research, right? Because there's been a lot of research on perspective taking, and look for these particular kinds of conditions that are going to give you a more nuanced read on what the effects of perspective taking are. I think that can really inform the kind of advice you're giving to students and attorneys about whether and under what conditions it's useful to engage in perspective taking of another person. Okay. Another example, some of you might be familiar with, a book from a few years ago called The Paradox of Choice. The key finding here was that adding more options results in less choice. The more options people have, the less likely they are to select any particular one of those options, because the notion is that they're sort of paralyzed by too much choice. And the original findings came from studies in one of the famous ones is they gave people a choice of different jams, and you could have a choice of just a few jams, or you could have a choice of a ton of different jams. And when you have a whole bunch of jams, people don't even want any jam. Right? If we think we want lots of choice, we advise people to brainstorm lots of options, but the finding here was that too much choice can have some problems. And another early study had to do with selection of 401k investment options, right? So it's not just jam, but decisions that have pretty significant implications. The more options you give people for their 401k investment decisions, the more likely they are to default, either not participate or to take some default option. Okay? So the danger sort of at the outset, right, is that we would sort of overgeneralize these findings, not completely adequately qualify them and say more choice is bad, right? And you saw that early on in this research. Okay, so now the literature has grown some more. You're starting to see studies that don't find that more choices results in less choice. You're starting to see studies that go the other way, right? So now what you're starting to see are headlines about, is the paradox of choice a myth, right? Those studies must have been wrong, right? This is a myth. But instead, I think it's really important to, again, think about whether and under what conditions more choice has particular effects, right? Under what conditions does more choice lead us to not choose, right? And under what conditions do more choices actually help us make better choices and maybe enable us to make more choices, right? So we need to think, and the people that work in this literature say, sort of we're at this moment where we need to think carefully about what are the variables here. We don't know yet, right? What are the conditions under which we see these different effects? But that's what we should be doing rather than arguing about whether or not there's an effect, right? Under what conditions do we see an effect? If we can figure that out, much more complicated, but we can probably give better advice to people who are designing programs and institutions and situations where choice is important.
So lastly, I want to talk a little bit about the fact that we're dealing with different disciplines here, and they have different burdens to prove. Okay, probably we're all familiar with the legal standards beyond a reasonable doubt, clear and convincing evidence, preponderance of the evidence. The standards are a little bit different in psychology research. This is not primer on statistics. So I will not be going into this, how we test for statistical significance and what that all means. But I just want to talk more broadly for a minute about the similarities and the differences between these fields. In psychology, we have type 1 and type 2 error, right? And type 1 error is our false positive, and type 2 error is our false negative. So that's similar to the law, right? Especially in the fact that in the social sciences, we worry more about a type 1 error. We worry more about a researcher saying, look, I have a significant finding, when in fact that's not true. Just like we worry more about what I would call kind of our hypothesis of a defendant being guilty, being found to be true when it's really not, right? We worry more about convicting the innocent than we worry about letting go the guilty, right? And it's similar in social science. We worry less about the type 2 error, more about the type 1 error. But the standards are different, right? So in psychology, what we're looking at is typically, and I have your confidence intervals, null hypothesis testing. I'm not going to be like getting into a long, deep discussion about those. But those are some of the things that you would possibly see in a psychological article presenting research. And I want to give the example that my statistics professor in grad school used about a spam filter for null hypothesis testing. Just the idea of a spam filter. Think about where you set the filter in terms of how much it gets rid of, right? So you all know you have a spam filter, and sometimes, like the email from your partner goes in the spam filter, and you're like, that's weird, because that shouldn't go there. And then sometimes you get really inappropriate things in your actual inbox, and it's not quite calibrated perfectly, right? But you hope that you set it at the right level. And you can set it at different levels, so you can kind of get more spam in your inbox, but you'll be sure that you get all the right things too. Or you can get less spam, but it might filter out some important things that you actually would want, right? And so I guess the thing I want to say about both of those is typically in psychology we set the bar at 95%, right? Typically we want 95% statistical certainty that we have the right result, right? What that means is 5% of the time we're comfortable with the fact that there's a 5% chance that this isn't the right result, right? But 95% certainty is what we're going for with these things. In the legal world, we have a different standard, right? We have a different standard entirely. Beyond reasonable doubt, we might think that that's kind of 95. We might think it's more like 99. We might think we want 100, kind of depends. Clear and convincing evidence is somewhere in the middle. Preponderance of the evidence, that's just 51%, right? That's like just a little bit better than flipping a coin. That's quite a difference, right? So we might say, oh, well, that's great. We can always use psychological evidence when we have a preponderance of the evidence standard. Well, I would say, wait, be careful, right? Why do you have to be careful? Well, because there are some important differences here. When we look at a psychological study, we're measuring effects across a group, right? We're measuring effects across a group, and when we have an individual case, we're always looking at individual culpability or other individual factors like witness, honesty, or whatever it might be. We're always looking at a specific person. We're not looking at a study, right? And so we've got a number of problems with that, right? Even if we're 95% sure that in the population something might happen, that it might be that the study was wrong. But even if the study's right, there's differences among individuals, right? And this one person might not be the person who actually bears out the research. Then, additionally, we have to worry a little bit about what the finding actually is in terms of our burdens of proof. So the example I'm going to give you, and that I'm going to leave you with, I think this is my last slide, is that there's a great study about risk assessment for future violence out there, and it shows that if you combine two actuarial models, your predictive power goes way up, right? And so basically they have this model, and in the condition of low, kind of an assessment of violence, both of the models say that you're going to have a low risk of violence. Only 2.8% of these folks have any kind of recidivism for violence in the specified time period. In the high group, you've got 64.2% of those same people having violence, having a violent episode in that next 20 weeks. Well, that's really statistically significant, and it's a great result, and you can see clearly that the models, the model is really working, right? It's predicting very well. The low dangerousness people really aren't repeating violence, and the high dangerousness people really are. And yet, when we think about applying it in the legal system, it might give you pause, right? Because if you're basing a sentencing decision or a bail decision or even a capital decision, right, on someone's risk of future violence, and you've got 64% accuracy, right, with the high group, that might trouble you, right? That might just not be enough. So you really have to take a look at what the finding is and determine whether it maps onto what the legal standard is. I think that's it. So I want to say thank you, and we have just a couple minutes for questions.
No.